Hello everyone and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to Barry to get us started.
Good evening or good day, everybody. My name is Barry Levenfeld. I'm a partner at Arnon Tadmor Levy, a firm based in Tel Aviv and Jerusalem. I'm joined by my partners, Liron HaKohen and Barak Platt. Do not be disturbed if you hear us interrupting each other. We are trying to arrange this to be a bit of a conversation with some interplay, and we encourage questions on your part. Besides, mutual interrupting is an Israeli cultural attribute that you should be aware of. Liron, you want to take us to the next slide?
Sure, of course.
Yeah. So this slide serves two purposes. The first is it's a blatant self-promotion of our firm because we're showing M&A deals that we've been involved with. But really the important part is just to look across the first line of tombstones, and you'll see the dates of these transactions. They range from the most recent in July of 2025 back to August of 2024. In other words, all of these occurred many months after the beginning of the challenging military situation with which Israel has faced recently. And part of what we're going to discuss today is, what has been happening in Israel on the M&A and tech scene, and why is it happening the way it is. So if you look at this chart, you'll see that 2024 exits were pretty much the highest in the country's history, which is pretty remarkable. The events of October 7th, well, there were two things essentially that preceded this great year. The first were the events of what we call the judicial overhaul, which was an attempt by the current government to reduce basically to try to reduce the ability of judicial intervention in what's going on, to sort of cut back on certain kinds. Can you move us back, Leon? I'm sorry. Back to, to this. So already in 2022, we had a lot of unrest due to the judicial overhaul. And in October of 2023, was when the military activities, the Hamas attack and the Israeli counterattack took place. Despite all of that, 2024 was a banner year. Now, what's been going on now in 2025? Amazingly, the M&A scene has continued. The H1 of 2025 has been the most active half year in several years, almost $40 billion of transactions in the first 6 months. We've had some big deals that are driving these numbers. Google acquired the cybersecurity startup Wiz for $32 billion, announced in March. And then we recently represented Palo Alto Networks in its acquisition of CyberArk, another Israeli company, for $25 billion. Add to that Advent's takeover of Sapiens, a $2.5 billion deal. And the rest is filled out by quite a few other smaller deals. I should just introduce some terminology that we might be using as we move forward. Israelis are very eager to claim credit for transactions. And what we call an Israeli company that's being acquired could be a company that really is organized under the laws of the state of Israel, but can also be what we call Israel-related, which would be a company most likely organized under the laws of the state of Delaware, but the founders are Israeli, the R&D takes place in Israel, and so those tend to be included in our statistics as well. So not only have the M&A deals been going strong, but H1 was also one of the best half years for private capital investments, seeing a 54% increase over the previous 6 months. And Nilon, if we move on, and alongside the private investments, we no go back one. There should be one.
Sorry.
Yeah. The public markets in Israel have also been in an exceptionally strong growth period. The Tel Aviv 125 index is up 57, almost 60% compared to last year. And even in the last month, the increase in value is by almost 7%. And without question, Israel's stock market has been stronger than any other Middle East counterparts and the like. And this is at a time when there is a bit of a consensus that the war has been sort of grinding down, and Israel has come in for tremendous censure and criticism on the part of other countries of the world. One can argue as to how much it's justified or not, but it is a fact. And despite that, the economic scene is continuing to grow. And we've seen this in our own practice as well. The resilience that's been shown during a period of armed conflict has been almost inexplicable. Companies are maintaining business continuity. There have been creative overcoming of setbacks. All this alongside joining civil society here as volunteers, helping in agriculture and cleanup and rebuilding and other activities that are civil activities. And the companies have been thriving here despite the fact that a large portion of their manpower has been doing lengthy military reserve duty. Tech companies have a essentially disproportionate number of officers and of people serving in significant units in the army. Many of them have done 100 to 200 days, sometimes more.
Just to note that Israel has a mandatory army service regime, so that's why I think it's just it's a cross border type thing in Israel that everyone just goes to the army thing, just to give a little bit of color into what is Barry saying.
Yeah, and a lot of people have returned to civilian life, but there's been a new call up. I know that a number of our lawyers at one point in our firm, I think we had, what was the number, 75?
Almost 90.
Almost 90 lawyers were called up simultaneously, which meant that partners like us found ourselves doing board resolutions and things like that because the deals went on despite the lack of people.
And just to put it in context, that's about 25% of the lawyers at the firm. So
yes, thank you, Brock. Yeah. So we've seen, as the previous slide showed, that foreign investors are still active. They're still seeking and closing acquisitions. If you can go back still,
Sorry.
Yeah. It was very interesting for a while. The RWI and the insurance providers, the reps and warranty insurance providers, sort of stopped doing stuff. There was a sort of a shock when the war broke out, but after a short pause, we find that they're back involved and happy to provide insurance for deals that involve Israeli targets. And counterintuitively, because so many tech people are serving in the army, and because the army units sort of throw in tech people from different areas of expertise, and because there are certain challenges to be dealt with on a real-time basis, prime among them providing medical attention to people in what they call the golden hour, within the sort of the first hour of somebody being wounded or hurt. All sorts of ideas for new startups germinated during the course of people doing their military service. So moving on, so how do we explain that all this is going on during difficult times? Well, one is that the fundamentals are still strong. In other words, Israeli companies usually have defensible, proven IP. It's not just a speculative play for future growth. People are buying companies that have real products out there. Also, the rising of cyber attacks and AI adoption, all of this makes Israel's very strong strength in cybersecurity and AI sort of must-have acquisitions, not nice-to-have acquisitions. Experienced international investors. It's not just the global funds with dedicated Israel teams, but we have quite a number of serial acquirers of Israeli companies. They acquire a company or two, and they instantly have on the ground a team of Israelis that are, looking around at what might be an interesting acquisition and are better able to assess risks through local diligence and understanding and not relying on the headlines. In other words, if you're sitting in a far-off country and you're just looking at the television or reading the New York Times, you would think that Israel is the place that you want to be far away from. But if you can talk to people on the ground in Israel, either from your own Israeli subsidiary or from your dedicated deal team in Israel, you learn what's really happening, and it can be very different from those headlines. And there's something about Israeli founders that's not the purpose of this. This could be another entire lecture, but there's a consistent innovation. Israel being such a small country, any tech company, in order to survive, has to scale globally from the get-go. It's not like you can rely on the Israeli market at first and then expand. You really have to have the global market involved from the beginning. And so whether in conflict or calm, these give you added values. I also have to say, just 1 minute on the role of the military in all of this. Some of the effect of the military is obvious, because a lot of the people that have learned cyber or communications or other kinds of things learn the actual substance in the military. But in addition to that, when you're in the military, you sort of learn control and command, and you are often in situations where failure is not an option. You have to get something done, and you have to get it done by a particular time. And that translates into getting that beta done before the conference in whatever country. And some of the same attributes that contribute to military prowess also contribute to the tech and startup world. So we're going to move on. I think we have one picture, I think, from, yeah, I just like this picture from the Wall Street Journal because that's more or less the view from our offices. And now we're going to, the second part of the program is talking more about sort of tips for doing Israeli deals and how Israeli deals may differ from what you'd be accustomed to. Our point of comparison, for the most part, are deals in the US, to a lesser extent, European deals. And so I think we can just go right ahead here. We're going to start with acquisition structures. And Barak, over to you.
Okay, thanks, Barry. And before I get started on that, just to kind of emphasize Barry's point about how amazing the last couple of years has been from a deal perspective, is you look at the deals Barry mentioned, Google's acquisition of Wiz and Palo Alto Networks' acquisition of CyberArk, and they are the largest acquisition globally that either of those companies has ever made, and they were of Israeli or Israeli-related companies during war. So a real vote of confidence in the Israeli tech ecosystem. So I'm gonna talk briefly about how to acquire an Israeli company. And generally, there are three structures that are used. The first and probably the most common for acquiring a private Israeli company is a share purchase agreement. And it's a pretty straightforward transaction. You have an acquirer come in and contract directly with the shareholders of the target company, pursuant to which the sellers agree to sell their shares to the purchaser, and the purchaser buys those shares, and all of the indemnity provisions and reps and warranties are contained in the share purchase agreement. It's a structure that allows for flexibility so that you can have a staggered sign and close. You can have if the circumstances permit, you can have a simultaneous sign and close. But there's a caveat here. And the caveat is that in order to acquire a private Israeli company through a share purchase agreement, you really need all or substantially all of the shareholders of the target company to agree. And that's because Israeli law provides for a statutory squeeze-out mechanism, and the law also allows for some flexibility in that statutory squeeze-out mechanism, and pretty much all Israeli or venture-backed Israeli companies have what's called a bring-along provision in their charter, which allows a certain percentage of shareholders to force all other shareholders to sell if they get an offer to sell all of the shares of the company. The problem is that the law is very unclear, and there's no case law interpreting it. So the law provides for statutory time periods of 60 days, pursuant to which once you have the requisite majority, you have to wait 60 days before you can squeeze out the shareholders. There's also another 30-day period. So first of all, it's long. It's unclear whether or not those statutory periods can be overridden, and there's no case law interpreting it. So in those circumstances where the companies are not confident that they can get 100% or close to 100% shareholder approval, typically what they use is a statutory merger. And I guess we can take one slide back, Liron. I'll mention briefly a tender offer. The Israeli companies law also provides for a tender offer, which in theory could be used to acquire public companies. In theory, they don't require much corporate approval. No board approval. They can be fast. The documentation is pretty simple, but there's a reason that they are virtually never used, and that is because in order to qualify and approve the tender offer, you need 95% shareholder approval, and it's not 95% of the shareholders responding, it's 95% of the issued shares. And even those shareholders who have approved the tender offer, they still have a period of 6 months following to ask for appraisal rights. So those conditions basically disqualify a tender offer from ever really being used. And instead, what acquirers of public companies or private companies, where they are not confident of getting 100% shareholder approval, is a merger, statutory merger. Statutory mergers have been used in many, many transactions in Israel, both private and public. They're pretty straightforward. You need a majority of each class of shares of the company. If you don't get that, you can still go to court and ask for approval of the court and, provide reasons why the court should approve it. And there's really no disadvantage in using but the only disadvantages are a timing issue. Unlike a share purchase agreement where you can have a simultaneous sign and close or a short period, a statutory merger requires typically 50 days between signing and closing, pursuant to which certain statutory procedures are complied with. And by the way, I should have noted that we've highlighted in yellow a number of provisions in these slides. They really are setting forth the differences between Israeli law and similar provisions in Delaware law. The other disadvantage of using a merger is that notices are required to be filed with creditors and in certain publications, and so it's harder to keep the deal confidential once it's signed. That said, I worked on a merger that closed a few months ago, and in the publications, we noted the name of the merger sub and the target company without identifying the name of the ultimate parent of merger sub. So we were able to preserve the confidentiality. You want to scroll? Yeah. The final structure that I want to talk about briefly is an asset acquisition. An asset acquisition, certainly from a purchaser perspective, has many advantages. First of all, you contract directly with the target company. You don't have to involve the target shareholders. You can pick those assets that you want to buy. You don't assume all of the liabilities of the target company. Employees who you hire come over clean without accrued rights because you're basically rehiring them. But there are pretty strong reasons that asset acquisitions are not common in Israel. And the first and foremost reason is that unlike a share purchase agreement or a merger, where the shareholders are selling their shares and receiving consideration from the purchaser directly, so they're paying capital gains tax. In an asset acquisition, the target company is selling its assets, so it is paying capital gains tax on the sale of those assets. And once it distributes a dividend to its shareholders, which is the consideration from that transaction, the shareholders have to pay tax on the distribution of that dividend. So there's two levels of taxation. In addition, unlike a merger or a share purchase agreement where the shareholders get paid at closing, in an asset deal, the target company gets the consideration, and the only way it can distribute the consideration to the shareholders of the target company is if it's the only way it will get capital gains tax treatment for that is if the distribution to the shareholders is made in connection with the liquidation of the company. What that means in short is that the company has to appoint a liquidator and begin shutting down its operations, which takes time. That means that there is a built-in delay between the closing and the time when the shareholders will receive payment, which typically is at least 3 months and can be 6 months or even longer. Obviously, from the target company's perspective as well, the target company has liabilities that haven't been assumed by the purchaser. There may be tax owed depending on what assets are type or sold. So we flagged here VAT. And from a corporate perspective, unlike an acquisition, unlike a share purchase agreement or a merger, where the target's legal entity is left intact, here it's closed down so that any type of contracts, commercial agreements, employees have to be assigned, which require typically consent by the other side of that contract. So again, just to kind of summarize, share purchase agreements are common for acquisitions of private companies where the shareholders are supportive or overwhelmingly supportive, and mergers are typically used for other scenarios, including public companies.
Thanks, Barak. Liron?
Yeah, so I think the second part of this presentation will actually take it a step back and also talk about startup establishment and venture investments in Israeli startups. Over the recent years, there was a lot of debate on whether or not to incorporate Israeli companies. And as Barry explained, Israeli companies means is companies that are founded by Israeli founders in Israel or as Delaware corporations. In the past, I would say last year definitely, but also from, I would say, circa 2023 with the judicial overhaul. And obviously after the October 7th events, quite a lot of companies currently elect to incorporate as Delaware companies and not Israeli companies. I think one of the main issues that helped out this event is not necessarily just geopolitical, it's the fact that QSBS tax regime, as well as currently now the big beautiful bill, have made various tax benefits available for US investors who invest in US corporations. So where US investors are keen to invest in companies, they want to invest in Israeli companies who are essentially Delaware entities. To be completely honest, on a substantive level, there are not necessarily too many disadvantages to incorporating a company in Israel, but the shift is pretty much undeniable. I think we listed in this table just a few of the items, be it in valuation or exits, be it M&As or IPOs. There's not necessarily, even from comparing data, any evidence that shows that Israeli companies are valued less both in M&As or in financings. But you do see that there are certain investors who prefer to either invest in local companies, irrespective of them being Israeli or UK or any other foreign domiciled corporations. They prefer to invest in US entities, or if there are certain US government funds or any other type of investors that will not invest in Israeli companies. From a tax perspective, there are even quite a few advantages to investing in Israeli companies, be it from a corporate tax perspective, also from transfer pricing perspectives. We'll talk a little bit more about tax regimes with respect to Israeli corporations later in this presentation. And as Barak mentioned, from a shareholder perspective, foreign shareholders are not subject to Israeli capital gains on a sort of a general statement on the sale of shares in an Israeli company. And therefore, that also shouldn't deter foreign investors from investing in an Israeli company. What there is the fact that Israeli is relatively a young country. It does not have a very rich legal precedent arrangements. So therefore, Delaware courts and Delaware law provide quite a lot of certainty with respect to certain aspects that Israeli law simply does not have. I think as Barak just explained with respect, for example, the bring along provision in Israel that doesn't have specific case law that better defines it. But an Israeli company is not subject to certain US regulatory burdens or even any other foreign regulatory burdens that would apply to the extent the company would be designated as a top co, which is not Israeli. Israeli deals pretty much have the look and feel of US deals. I think we are very familiar with the NVCA trends, the National Venture Capital Association trends for US investments. Most of the provisions that we have in place, even if they don't structure exactly the same way as the NVCA documents, include pretty much the same concepts, be it liquidation preference, registration rights, and anti-dilution protection. So any attorney who has done US investments or VC investments would feel quite comfortable reading articles of association or a shareholders agreement of an Israeli company, and they would find very similar concepts to the ones that they're used to seeing. Where, as mentioned, quite a lot of Israeli companies are now being set as Delaware topcos with an Israeli subsidiary. So where the parent is a US company, the deal docs would pretty much be based on NVCA standards. So you'd have Israeli counsel, both sides, basically negotiating the NVCA standard template forms for a financing. SAFEs, simple agreement for future equity, are the preferred bridge instruments in Israel. Again, we view the US standard Y Combinator templates as our go-to. We'll talk about it again a little bit more in greater detail in one of the next slides, but the idea is that we take those SAFEs, somehow adapt them to conform to certain guidelines that are issued by the Israeli tax authorities, but again, they have the look and feel of US SAFEs. We don't necessarily use convertible loans or notes, which I know are very prevalent, be it in the US or in Europe, due to Israeli taxes issues. But again, those can also be seen and can be included. Mary, do you want to take the tax part?
Yeah. Let's go to, yeah. So the purchase and the sale of an asset in Israel in general is subject to capital gains tax, and that includes shares of Israeli companies. However, when a foreign non-Israeli resident sells an Israeli share, that foreign resident has an exemption or a zero rate of Israeli tax. Where do things start to get complicated? The Israeli tax authorities take the position that whether or not the seller has a exemption from Israeli tax, the buyer has a withholding obligation to withhold Israeli tax unless the buyer has been assured that the seller has some kind of exemption. And the exemptions held by non-residents are not automatically implemented. You often need a tax ruling. So that would make sense if you're a foreign buyer buying shares of an Israeli company. But the Israeli tax authorities, one of my partners says the Israeli tax authorities sort of operate like a startup, a revenue generating startup. They're always trying to come up with innovative ideas to make money. So,
and they're good at it.
And they're good at it, and they're frustrating. So we had talked about these Israeli-related companies, Delaware Corporation. So if that Delaware Corporation is managed and controlled from Israel, and there are all sorts of tests as to what management and control means, or if that the main significant assets of that Delaware Corporation are based in Israel, in those cases, the tax authorities will take the position that the Delaware Corporation is subject to Israeli tax. That can lead to a position where you have a non-Israeli buyer, acquirer, buying shares of a non-Israeli company from a non-Israeli shareholder seller, and the ITA is saying there's a withholding obligation and it's in theory subject to Israeli tax. This is probably the biggest surprise to buyers. What it requires, it's not the end of the world. There are ways to deal with it, but basically the buyer has to make sure that it either has a tax ruling or that the sellers provide exemptions from Israeli tax. And so the buyers in that situation are dealing with issues they would never think they'd have to deal with, but it's important to deal with it.
And let me just comment as well that it's not only a surprise to the buyers, but to the financial investors in the target company, right? Because you have a foreign investor investing in typically a Delaware corporation, and they go to sell the company and are very, very surprised, to put it mildly and politely, that they have to now start dealing with the Israeli tax authority to get a withholding exemption.
Yeah. There is a fairly well developed and sort of standardized set of clauses that Israeli counsel will use in acquisition agreements to try to account for both the process and the timing of getting the Israeli exemptions. Next, Leon.
So, I mean, I think
I'll
we
let you
covered
do
it.
that.
Yeah, so we covered it a little bit when we talked earlier about safes. As mentioned, I mean, we see quite a lot of bridge financings being conducted through safes, and the reason why we're mentioning it here is because I think early 2022, there were a lot of questions being asked on whether or not safes are considered to be by the Israeli tax authorities as equity or debt instruments. And why does it matter at all? Because as Barry just mentioned, foreign investors are not subject to capital gains in Israel, but they are subject to tax on interest proceeds derived from from selling shares of an Israeli company. So if the Israeli tax authorities would view safes as debt instruments, any shares that were issued on account of conversion of the discount component or the cap component could in essence be deemed interest. And on that interest, foreign shareholders would be liable for tax in Israel. So in order to resolve this ambiguity, mid-2023, after a lot of discussions between auditors and certified public accountants and attorneys, also from our offices with the Israeli tax authorities, because as mentioned before, they're very entrepreneurial, but they're willing to listen and they're willing to sit and they're trying to find solutions that would make sense. The ITA issued certain safe harbor guidelines to make sure that if a safe meets those guidelines, then they would definitely be deemed as an equity instrument. What's important to note is even if a safe doesn't meet those guidelines, okay, if it's structured in a way, and I'll talk in a second about what are these guidelines, but basically if it's structured in a way that's a little bit different, it doesn't necessarily mean that the ITA would consider it a debt instrument. It would just mean that you would need the be it the investor or be it the purchaser or be it whoever, would need to approach the Israeli tax authorities and get a bespoke ruling or bespoke decision with respect to that specific safe. The guidelines are pretty procedural. They relate to the amount of investments. They relate to the fact that the company undertakes not to claim certain tax expenses, which in essence it would never do. They're not difficult to meet. But the reason why, we're mentioning it is because to the extent you are either being asked to review or to negotiate a safe agreement with an Israeli entity, they should be drafted to comply as much as possible with the ITA guidelines, and therefore you should contact be it an Israeli attorney or an Israeli accountant to make sure that this is done to the best of all our abilities.
Okay, thank you. Another area where I confess that the ITA did something reasonable. I much prefer dumping on the ITA, but when it does something reasonable, we have to give it credit. There is a question in many acquisition agreements, the portion of the consideration payable to founders or key employees is retained or held back and only paid out over time, so that it serves as a mechanism to incentivize them to stay with the company. So these holdbacks or retention provisions, which are very typical and serve an important function, business function, raise a question as to what is the nature of the income from the held back shares. Because on the one hand, it's capital gains, just like anybody else, because it's the same shares that everybody else got, but you're getting them a bit later if you're a founder. But on the other hand, because your entitlement to the proceeds from the sale of those shares depends on your continued employment with the target company, there is an argument to be made that those proceeds are ordinary income. And the way it works in Israel is all you take, there's different assessing offices in different parts of the country, and all it takes is one aggressive assessing officer in some far off part of the country to take a really, really crazy position, and then EY and other accounting firms know about it, and we lawyers rush to the bottom of the barrel, all assuming the worst. So in this case, there was, big brouhaha as to how to handle this. And the ITA actually came up with a circular that clarifies the provisions pursuant to which you can pretty much be guaranteed of capital gains treatment. And in fact, the prerequisites are things that you would normally do anything. There's no big surprises here. The price per share payable to the founder or the key shareholder has to be the same as what other shareholders received. The shares have to be held for a certain period of time. And probably most important, the founders or key persons have to also have a sort of industry standard employment agreement so that arguably this isn't their employment income. This is in addition to their employment income. There are some procedural things the founders don't like. They have to report and pay to the ITA tax based on the entire consideration, even the held back amount early on. What that does do is dictate that you have to make sure that the founders or the key people get enough money at closing to pay their taxes. So it does sort of impinge on sort of your full freedom to design the retention process. But if done appropriately, you can do it, and you can do it in a way where the founders are assured that they will have capital gains treatment. Next, I think. This is another big issue in Israel, and it ties in actually to what Liron was saying about where to set up the company, and an unfortunate situation from our perspective that I recently dealt with. The ITA takes a very aggressive view towards post-closing IP transfers. And what do we mean by that? It's very typical for a big global company to buy an Israeli company and to want to pretty much the day after the acquisition to take the IP from the Israeli company and transfer it to Bermuda or Ireland or Singapore or wherever it may house its global IP. And this is done as part of its global IP tax planning. And the Israeli authorities are worried about what they call IP flight in these cases. We can talk about whether that's something to be worried about for real, but they are worried about it. And that transfer of IP out of Israel is subject to Israeli corporate tax. I mean, it's really capital gains tax, but technically it's corporate tax. Now, we have clients and other law firms that call this exit tax. It's not an exit tax. It would be, you would pay capital gains tax on the transfer of IP out of an Israeli company to a foreign company, no matter when it took place or in what context it took place, because there's a capital gains regime. But what's particularly galling about it is if you've just paid $1 billion for an Israeli company, and now you own that Israeli company, and now you want to transfer the IP out of that Israeli company to your Ireland branch, all of a sudden you're hit with a big tax bill. And what's the valuation of the IP for the purposes of that tax bill? Well, the ITA will say, well, when you bought that Israeli company, everything that you paid for that Israeli company was for the IP. So in that $1 billion acquisition, they'll say, okay, now you've just transferred $1 billion value of IP. Let's look at the basis of that IP. And the basis is calculated the way you would in another country. It's, you know, the monies and funding and whatever that went into creating the IP. And if it's a successful acquisition, there's a huge gap between the amount of the basis and that $1 billion. And so the company is faced with a gigantic tax bill. Now, what do you do about that? So first of all, you fight the fight. You try to see if you can prove that part of that $1 billion was not paid for IP, but was paid for something else. Usually pretty difficult. You get creative. You say it's been paid for contracts. It's been paid for non-competition.
Personnel.
For personnel. The ITA tends not to buy that. You can set it off against, depending on the specifics of the situation, you can set it off against net operating losses and things like that. But usually there is a big dispute between the target company and the buyer. Now, some buyers are totally agnostic about this because they have credits that they can take in other parts of their global tax planning, so it doesn't matter to them. But you have to be aware of this from the very beginning so you can plan for it appropriately for the next step. Now, and there's a bunch of litigations that we're involved with fighting about the valuation. There's another complication, and that is sometimes there won't be any transfer of IP, but rather there'll simply be a change of the business model. In other words, Before the acquisition, you have an Israeli company that is independent, that is creating products based on its IP, selling those products and making a profit. Afterwards, even if the IP is left in Israel, almost always the parent company wants to put into effect a cost plus arrangement, whereby all future IP is being made in Israel and transferred and owned by the foreign buyer, and the foreign buyer pays the cost and expenses of creating that IP plus some agreed plus factor. And now the ITA has taken the position that that change in business model is in itself a sale of assets. So there have been various cases. There's one case that rejected the ITA position, but it was on very specific facts and circumstances. It's not clear that it will be the same. So I want to quickly talk about two practical things that have come from this. We still have time. Yeah, we're doing okay. One is a new transaction with a major global buyer that did a whole tax analysis because they know they're going to be investing in an Israeli company. They know that they want to transfer that IP to outside of Israel at some point afterwards. And we had our best tax minds both here and at one of the accounting firms. And we came to the conclusion that in that situation, when you know ahead of time that you're going to be transferring IP out of Israel at a high valuation, you're better off setting up the company initially as a non-Israeli company, which is not the, all things being equal. The way I put it, if your Israeli lawyer suggests that you set up outside of Israel, he's making a recommendation against his personal best interest, and you should listen to it. And so that's the recommendation that we made there. Second, we had a situation where we're representing the buyer of an Israeli company, of a Delaware corporation that already was after a transfer from an Israeli company. And the ITA has taken this position of that it's a sale of assets. And the Israeli company is fighting it. And the current Delaware company, we're fighting it with an aggressive accounting firm. But we're coming in and buying the whole complex, and we want certainty. And basically, we said to the Israeli company, okay, you know what? You give up on that argument. You agree with the tax authorities that all the IP has been transferred out and is located in the US, because when we buy it, we want to know it's in the US and not subject to the clause of the Israeli tax authorities in any way. And in the context of the transaction, a $60 or $70 million settlement with the ITA, as a result of which the IP is located outside of Israel, made a lot of sense, and that's where we're moving. So again, this is something to take into account in your planning when you're buying an Israeli or Israeli-related company. Okay.
Or selling.
Or selling, of course. Moving on. Okay, Barak, your turn.
Okay, so before I get into this, I just want to remind you that we are happy to answer your questions. So to the extent that you have any, there's a Q&A tab below, so feel free to let us know. So the Israel Innovation Authority, for those of you who might have heard in the past of the Office of Chief Scientist, it's the Office of Chief Scientist with a relatively new name. But it is a mechanism whereby the Israeli government provides funding to Israeli technology companies to help them to develop their technology. It's non-dilutive. The IIA does not receive any type of equity interest. It's not a loan, but it is repayable from royalties on sales of products or services which incorporate the funded technology. But the repayment amount is capped at 100% of the amount of the grant plus interest. So in many ways, it's a very, very, very sweet means of helping to fund a young technology company. The issue is that there are restrictions on the use and transfer of the technology, which can often come back to haunt the recipient of that IIA funding, especially in an exit. So basically, the restriction is that the IIA funded technology cannot be transferred outside of Israel without the IIA's consent, which is received upon the payment of an amount to the IIA, which is a multiple of the IIA, the amount of IIA funding. So if in Barry's example, we represent a buyer and the buyer wants to come in and buy technology and then repatriate that technology outside of Israel following the closing, in addition to the tax complication that Barry described, in order to repatriate that technology outside of Israel following the closing, a payment to the IIA would need to be made in an amount equal to 3x or 6x the amount of funding received by the IIA, depending on a number of factors. So this is an issue that arises in every acquisition of an IIA funded company. Certainly when we are representing the buyer, it's one of the first issues that we tell the buyer that they need to find out from the company, because basically the companies will often take the target companies will often take the position that we're selling you our company. Whatever you want to do with the technology after the closing is fine, but that's on you. And whereas the buyers are coming in saying, we want the technology free and clear. So it typically is it's a commercial issue, which the question is who's going to pay it. And there's a range of solutions. It's not uncommon for the sellers to pay it. Sometimes you see a buyer who's willing to pay it, and it can be split as well.
Just to echo Barak's point, though, is that sometimes, I mean, the LOI stage and for an acquisition is negotiated before Israeli counsel is brought into the picture. So if this is the case, whenever there's a sort of negotiation with an Israeli company whereby there's not necessarily an Israeli attorney involved, I think it's important to ask the question of whether or not the company received IIA funding, even in the LOI stage, because it's better to fight about this issue in the LOI stage. Because as Barak says, it often comes up when the documents are in play and it's less advantageous.
And the other issue I want to mention here is that the law is unclear as to how earnouts are treated. So is the amount of the earnout added to the amount that's payable at closing in order to remove the restrictions, even though it hasn't been paid? Is that amount payable, when it's paid? Because again, the earnout component affects the 3x or 6x amount that is payable. So
I was involved in a transaction where this was actually an issue, and we were able to negotiate a certain agreement with the IIA, basically setting aside monies from the acquisition in escrow, just to wait to see whether or not the earnout is going to be received. To the extent it wouldn't, it would be returned to the shareholders that were selling the company. That being said, it was a difficult process. Also, just to implement it, we needed a third-party escrow agent. There were various discussions and meetings with the IIA. Again, they were receptive to hearing the issues. They were trying to find solutions, so I can't fault them for that, but not an easy process.
So I just want to note that we did receive a question. So I'm going to read it and see, Barry, Liron, if you guys have any thoughts. It's a tax question, but the question is, in a UAE acquisition of an Israeli startup, can the Israeli UAE tax treaty be used to reduce or avoid the 23% tax on post-closing IP transfers, or is it still necessary to structure with a UAE parent and Israel as R&D? I mean, my guess is, I'll take a stab at this, but my guess is not, I don't believe any of us are familiar with the substance of the UAE-Israel tax treaty. But Israel has tax treaties with a number of countries, including the United States. And those tax treaties do not typically impinge upon or reduce the acquirer's obligation to pay an IP tax, because that again, from the Israeli tax perspective, that is seen by the Israeli tax authority as a sale of that IP to the foreign entity. And so, so capital gains presumably would be owed regardless of the UAE tax treaty, but that's certainly something that we could run by our tax department.
Yeah. I mean, just to add, I think that typically the tax treaties will reduce interest, will reduce tax on dividends, but would not necessarily reduce tax on capital gains. But that's the type of question where we go to our tax people. Yeah. Barak, anything else on IIA?
No, I don't think so.
Okay. So I'll be very quick here. Actually, just so before going into this, I see now on the list of participants a lot of friends of the firm and a lot of friends, my friends personally, and I just wanted to thank everybody for joining. We'll have another minute to do that later on. Very quickly on HR, I think we all know that there are sort of two areas of the law that are specifically very, very local, and that's HR and real estate usually, where sort of you can have general principles, but they always have to be applied based on the local law. So in Israel too is no different in the sense that there are some unique Israeli things to take into account. Non-compete agreements were very much like California, very difficult to enforce non-compete, in some ways even more difficult than California because we don't have a clear sale of business exception. We have the same kind of misclassification concerns between a contractor and an employee that have to be dealt with and could raise potential liability. We have a statutory severance obligation here that is often dealt with by well-run companies in terms of making deposits into various funds. And there are ways to make sure that that severance liability will not be greater than what's applied for in the books, but that's something that always has to be checked out separately. We have overtime exposures that in some ways may be surprising because just because you're paid a lot of money doesn't mean that you're not entitled to overtime. The exemptions for overtime are pretty much limited to managerial people. And so your super competent programmer or CTO might be might be able to claim or entitled to overtime. There are also ways that well-run Israeli companies sort of deal with this in their employment agreements. We don't have at-will employment. We have, thank God, national health insurance. So a lot of the sort of medical benefits that U.S. companies want to provide are not of particular interest to Israeli employees. And we have all sorts of mandatory leave entitlements. Besides maternity leave, we have military leave, unfortunately, which has been a big issue of late. Not a big issue, but people have been required to take military leave. We also have leave entitlements for fertility treatments. We have the ability to have paternal and not just maternal leave. And so also in sort of examining the workforce, if you're about to acquire a company, you want to make sure that you sort of take into account who's on leave, where, and when. So I think that sort of, oh, we have pictures of the three of us. How nice.
Pictures of us, yeah, so now you see it like 2 times, yeah.
Yeah. So we thank you very much. Liron or Barak, any last words before we sign off?
Actually, we did receive another question. How do
Okay.
employee stock option plans work in Israel similar to the US?
Okay.
So
Liron, you want to do that one or I can do that, whatever?
Very similar to the US. Basically, most of the stock option plans include relevant provisions that are, if we're talking in an M&A context, that allow for the sale of, the automatic sale of exercised options to the acquirer. There are certain capital gains regimes that would apply to equity incentive plans, be it, it's called 102 tax options. They're very similar to ISOs in the States, which means that if you comply with a certain set of rules that is dictated by the ITA, that the employee who received such options in the event of a sale would be able to sell those shares and only pay capital gains on that. So I think it's very, very similar to what you would see in US stock option plans.
Yeah, I mean, just to add a bit, if there's a Delaware corporation that wants to hire Israeli employees, so what they typically would do is we would help them prepare an appendix to their US stock option plan. And there's a technical requirement here, which is that in order to qualify under 102 or our equivalent to ISO, the options have to be deposited with a trustee for a period of 2 years. But again, the underlying concepts are pretty similar.
And one other thing to be aware of is that if options are being substituted or assumed, one wants to make sure that the option holder continues to have the benefit of the 102 provisions, and for that purpose, a tax ruling is normally required and can be obtained in due course without too much problem. So I think we're saying goodbye, and we thank everybody for participating. And again, we let you know that you should be getting an email that has a copy both of the recording of the session as well as of our presentation.
Thank you all very much.
Thank you.
Thank you. That wraps up our masterclass. Thank you all for joining us today. A special thanks to our speakers, Lyron, Barak, and Bari, for their time and effort in preparing and delivering the session. As mentioned just now, the session was recorded, and we'll be sharing a copy of the recording and the slides with you in the coming days. Thank you once again, and enjoy the rest of your day.
Bye-bye.